Court rise. Yes, Mr. Guthrie.
My Lords, in this appeal, I appear on behalf of the Appellant Attorney General. My learned friends Sir Fenton Ramsahoy and Mr. Anand Ramlogan appear on behalf of the respondent.
Yes.
My Lord, I can take the underlying facts quite shortly. The respondent was employed as an acting director of the National Lotteries Control Board, which is a statutory body established by the National Lotteries Act for the promotion and conduct of national lotteries. The National Lotteries Control Board is a statutory authority subject to the jurisdiction of the Statutory Authorities Services Commission. She alleged that she had been discriminated against because she was suspended in circumstances which would not have been applied had she not been effectively a woman. And she brought proceedings for constitutional redress solely against the Attorney General. My Lord, there's one matter in her claim which I should clear up in case it causes any confusion. The Lordships will see that at the beginning of the record on page 2, her claim includes a claim for damages.
Yes.
On page 6, there is a statement, the claimant claims no damages. That appears to be generally accepted to be simply a mistake. And indeed the courts below treated her claim as including a claim for damages. I don't believe anything turns on the point, but in case your Lordships had noticed, there was that inconsistency.
A rather unusual claim to claim no damages.
Well, indeed, but I think, I've had a brief word with my learned friends. It's a hangover from the days of judicial review and procedures in Trinidad.
Yes.
And different rules applied when damages were claimed and when they weren't. My Lords, the Attorney General applied to the court to be removed as a party and raised that issue as a preliminary issue. As your Lordships will see from the judgment at page 192 of the record, and that matter was dealt with on its own, so that the underlying merits of the respondent's case were not examined at all. My Lords, the reasons for the court's decisions are also able to see in summary quite briefly. The judge's decision is helpfully summarised in the course of his judgment at page 203 of the record.
You're using the top, the page at the top.
Yes, my Lords. I'm afraid sometimes the last figure has been cut off, but I hope it's not going to be both pages at once. It's the top right-hand corner numbers. And in fact, the passage is in paragraph 20 and begins at the foot of page 202, where the judge says, now, even though the allegations in effect concern state action in the broadest sense of the term, given its autonomous nature and the rationale for its creation, it seems to me that where there are allegations against the SASC, which is the acronym of the Statutory Authorities Services Commission, such as there are in the instant case, for breach of the claimant's constitutional right to equality of treatment from a public authority in the exercise of its functions, and on the assumption that a constitutional motion is the appropriate procedure, the appropriate party against whom the constitutional motion should be brought is the Commission itself. That would have the salutary effect of preserving the Commission's autonomy and provide a commensurate degree of insulation by ensuring that it has independent representation. Further, there is no risk of prejudice to the state having regard to the provisions of the CPR, the Civil Proceedings Rules. Pursuant to Rule 56.10.2 CPR, a claim form relating to an application under Section 14.1 of the Constitution must be served on the Attorney General. Further, pursuant to 56.10.4, where the Attorney General is not a defendant, the claimant must give notice of the claim to the Solicitor General. That would give the state the opportunity to consider such an application and decide on its future course of conduct, including whether it wishes to be heard in the proceedings. And for the moment,
has it any effect at all on the claimant's position, who the nominal defendant happens to be?
well, we would say the claimant is perfectly protected. The whole case is about, if I may summarise, who is the right person to be the defendant to a claim of this nature.
The remedy is going to be available, whichever happens to be the right
same
defendant.
remedies will be available.
Yes.
My Lord, if I can perhaps just go to the decision of the Court of Appeal in the same way and show you the heart of that. It's at page 268, and in paragraph 5, where Mr. Justice Hamel-Smith says this: Section 14, subsection 1 of the Constitution makes express provision for applications to the High Court for redress where one is alleging that there has been or is likely to be a breach of any of his fundamental rights secured by Section 4. Section 14, subsection 3 makes it clear that the State Liability and Proceedings Act, Chapter 802, applies for the purpose of any proceedings under this section. Section 19 of the Act provides that all civil proceedings against the state must be instituted against the Attorney General. That mandate has been followed from time immemorial. The Attorney General is of the view that it need no longer be followed, and the primary offender, as the SASC has been described, must be brought to the fore as the defendant. Lord, perhaps I could leave it at that for the moment, because your Lordships will need really to appreciate the issues to look at the legislation in a little more detail. And if I can take you to the bundle of authorities and begin with the Constitution. My Lord, it's probably more convenient if I go, so to speak, statute by statute and show you all the relevant sections which are likely to be necessary to consider. Lord, the Constitution is under Divider 1. Lord, I would go first to the interpretation section, which is section 3. Simply for one definition, over the page, towards the foot, there is a definition of service commission. That is defined to mean the Judicial and Legal Service Commission, the Public Service Commission, the Police Service Commission, or the Teaching Service Commission. Well, those are the 4 constitutional commissions, if I can call them that, dealing with, well, what is obvious, the judiciary to begin with, etc. That definition does not include the SASC. Well, if I can then go on to section 4, which is the constitutional right which was invoked by the respondent. It is, of course, in part 1, the Fundamental Human Rights chapter. it is hereby recognised and declared that in Trinidad and Tobago there have existed and shall continue to exist, without discrimination by reason of race, origin, colour, religion or sex, the following fundamental human rights and freedoms, namely, then if one drops down to B first of all, the right of the individual to equality before the law and the protection of the law, and to D, the right of the individual to equality of treatment from any public authority in the exercise of any functions. And those are the, so to speak, freestanding constitutional rights. Section 14 provides for their enforcement. Section 14.1 reads, for the removal of doubts, it is hereby declared that if any person alleges that any of the provisions of this chapter has been, is being, or is likely to be contravened in relation to him, then without prejudice to any other action with respect to the same matter which is lawfully available, that person may apply to the High Court for redress by way of originating motion. The High Court shall have original jurisdiction to hear and determine any application made by any person in pursuance of subsection 1, and to determine any question arising in the case of any person which is referred to it in pursuance of subsection 4, and may, subject to subsection 3, make such orders, issue such writs, and give such directions as it may consider appropriate for the purpose of enforcing or securing the enforcement of any of the provisions of this chapter. And then subsection 3, the State Liability and Proceedings Act shall have effect for the purpose of any proceedings under this section. And your Lordships recalled that that was referred to by the Court of Appeal in the paragraph which I showed you. One then needs to look at section 76, subsection 2, which provides that the Attorney General shall, subject to section 79, and my lords, that isn't included in the bundle, but it simply deals with what happens if a minister is ill, that sort of thing.
Thank you.
Be responsible for the administration of legal affairs in Trinidad and Tobago, and legal proceedings for and against the state shall be taken in the case of civil proceedings in the name of the Attorney General, in the case of criminal proceedings in the name of the state. It refers to legal proceedings for and against the state.
In case anybody wants section 79, it's actually set out in Sir Fenton's argument at page 10.
Thank you, my lord. If I can then ask your lordships to go to divider 7, but I'm afraid an accident has occurred in that the State Liability and Proceedings Act, including under divider 7, is taken from an earlier revision of the laws. I have an up-to-date copy, including the amendments which are necessary to see. So could I ask your lordships to look at that instead?
Yes.
It would be I should perhaps tell your lordships that this is taken from the 2006 revision, but there is a relevant amendment. Well, can I ask you to go first again to the interpretation section 2. You'll see that under subsection 2, the second definition is of civil proceedings. Civil proceedings includes proceedings in the High Court of Justice or a petty civil court for the recovery of fines or penalties, but does not include proceedings analogous to proceedings on the Crown side of the Queen's Bench Division in England. then at the bottom of the page, proceedings against the state, which I just include for completeness' sake, includes a claim by way of set-off or counterclaim raised in proceedings by the state. There's a definition of state on the opposite page. Any reference, the state means the Republic of Trinidad and Tobago. And then subsection 3, any reference in parts 3 or 4 to civil proceedings by or against the state, or to civil proceedings to which the state is a party, shall be construed as including a reference to civil proceedings to which the Attorney General is a party, but the state shall not, for the purposes of parts 3 and 4, be deemed to be a party to any proceedings by reason only that they are brought by the Attorney General upon the relation of some other person. And then I ask your Lordships to go on to section 19. Section 19.1 provides, subject to this Act and to any other written law, proceedings by the state may be instituted by the Attorney General. Subsection 2, subject to this Act and to any other written law, proceedings against the state shall be instituted against the Attorney General. Then over the page, I ask you to go to subsection 8 and 9 in particular. Proceedings against an authority established by the Constitution or a member thereof, arising out of or in connection with the exercise of the powers of the authority or the performance of its functions or duties, are deemed to be proceedings against the state. In this section, authority means a service commission as defined in section 3, subsection 1 of the Constitution. If I can ask your Lordships just to remember that I showed you the definition of those service commissions as not including the SASC, but including the ordinary constitutional commissions.
Do we also get some assistance from the definition of agent in section 2, subsection 2? Because that excludes a statutory corporation, except where the state has entered into an express contract of agency with the corporation. And statutory corporations fulfil public purposes, which is, as I understand it, one of the respondents' arguments for saying that the statutory authorities commission should be regarded as part of the state, but evidently statutory corporations are not.
Yeah. Well, perhaps I could think about that if I may.
Have we seen the term agent in any of the provisions to which you referred us? I hadn't thought we did.
No, my lord, I don't think so. But
I mean, unless you find agent in a relevant provision,
yeah.
I'm not clear why you need to look at the definition of it.
Well, Lord, I think it may be foreseeing what Sir Fenton may be going to say. Lord, perhaps I could repeat. Perhaps I could think about that. Lord, I would just on the question of sections 8 and 9, subsections 8 and 9, Lord, those were introduced by an amendment in, as your Lordships will see, there are two amendments with reference to section 19 referred to. Act 8 of 1976. And
where are you looking to find this?
19, section 19, my lord.
Sorry.
And the side note.
Oh, it's the side note. So sorry, yeah.
I'm sorry, you will see reference to, this is the amendment which was not included, unfortunately, in the copy which we included in the bundle, but because it postdates that revision of the laws, 6 of 1998. Lord, really, I think only for purposes of interest. I mean, the section 8 and 9 were introduced by Act number 6 of 1998. There was some reference to the amendment in the courts below, which is, it's referred to on page 188 of the record. in paragraph 6 of the Attorney General's submissions before the High Court. You'll see that section 19.8 is mentioned in paragraph 3 of the applicant's arguments. This section was an amendment to the State Liability and Proceedings Act and is contained in the Act number 6 of 1998. It is respectfully submitted this honourable court can take judicial notice of the fact that it was passed in response to the threat by the applicant respondent in Rees and others in Crown to levy on the members of the Judicial and Legal Service Commission for his costs after he had succeeded in judicial review proceedings against them. Well, Rees and Crown was a case which would come before your Lordship's board and involved the removal of a judge in circumstances which were found to be wrong. But Lord, I don't think the reason for the amendment is probably of importance, but that seems to be what it was understood to be. In the same Act, the State Liability and Proceedings Act, can I ask you to go on, please, to section 25. Subsection 1. Subject to this section, any reference in this part to civil proceedings by the state shall be construed as a reference to the following proceedings only: proceedings for the enforcement or vindication of any right or the obtaining of any relief which, if this act had not been passed, might have been enforced or vindicated or obtained by any such proceedings mentioned in paragraph 1 of the schedule. Proceedings for the enforcement or vindication of any right or the obtaining of any relief which, if this act had not been passed, might have been enforced or vindicated or obtained by the Attorney General. All such proceedings as the state is entitled to bring by virtue of this act, and the expression civil proceedings by or against the state shall be construed accordingly. Subject to this section, any reference in this part to civil proceedings against the state shall be construed as a reference to the following proceedings only. Lord, I didn't really read the subsections out. You'll see that the difference in paragraph A refers to paragraph 2 of the schedule. And the schedule is at the end of the Act, entitled Proceedings Abolished by this Act. Paragraph 1 refers to various old forms of proceeding, and so does paragraph 2. Lord, at this stage, can I then ask you to look at the Supreme Court of Judicature Act? Which is a divider 3. Section 13. In any action or proceedings brought by any person alleging that any of the provisions of sections 4, 5, 6, 11 and 13 of this Constitution have been, or the Constitution has been, is being, or is likely to be contravened in relation to him, the High Court shall give notice of the question arising in such proceedings to the Attorney General, who shall be entitled as of right to be heard, either in person or by counsel, notwithstanding that the state is not a party to the action or proceedings. And we comment that it plainly envisages constitutional proceedings being brought against persons who are not the Attorney General. And indeed, we would say the same in relation to the deeming provisions of section 19.8 and 9, which would not be necessary if proceedings had to be brought against the Attorney General in the first place. My Lord, may I return then to the judgment of the Court of Appeal, paragraph 5. Setting out the reasons why the judge was found to be wrong and the Attorney General was found to be the correct defendant. I've read paragraph 5. Under paragraph 6, it is trite law that one of the main objectives of Chapter 1 of the Constitution is to prohibit contravention by the state of any of the fundamental rights and freedoms set out in Section 4. Lord Diplock in Maharaj confirmed that the protection afforded by Section 14 was against contravention by the state or some other public authority endowed in law with coercive powers and not by another private individual. Accordingly, any application to the High Court would be considered civil proceedings against the state and not a private individual. We submit that that isn't right. There is no argument that these proceedings have been brought against the correct party. The appellant has done precisely what the Constitution and the Act, in other words, the State Liability and Proceedings Act, requires her to do to bring the action against the Attorney General. That much is clear. My Lord, that might read as though it was something which had been, so to speak, accepted generally, but it was the court's finding, not the there wasn't any argument on the part of the Attorney General. I think it should have been put like that, because if one reads the skeleton argument, I don't want to take you to it, it does make it clear that the Attorney General was in fact contending that
The Court of Appeal appear to be saying that by definition, any Section 14 of the Constitution proceedings necessarily must be brought against the Attorney General.
Yes.
And that is the consequence of 14.3, which introduces the State Liability and Proceedings Act. So it's for all the world as if you read that section as saying, as I've indicated, that you could in fact almost forget talking about the State Liability and Proceedings Act and say any proceedings under this section must be brought against the Attorney General.
Well, we say that the Court of Appeal effectively conflated the state with all public authorities.
Right.
And we say that is right. The fact that a person or a corporation is exercising a public function doesn't make him or it the state.
Well, Lord Diplock appears to make exactly that distinction. Do you have the page reference?
Well, I was going to go to Maharaj because it's a case which was rather interesting and relied on quite heavily by both the judge for his conclusion and the Court of Appeal for their conclusion. But in fact, exactly the same passage was relied on as meaning diametrically opposed things. But I do have the page reference, certainly if your lordship would like it now. It's when I come to it, my lord, it's under divider 13, and the particular page reference is 396. But if I could just come to it a little later, if I may. But Lord, it's obviously true, my lord, that all proceedings against the state are proceedings against a public authority, but not the other way around. And that is where we say that the court fell into error. And my lord, if I just go back to the judgment, paragraph 8, no sustainable argument that the SASC is not a public authority endowed with coercive powers and exercises statutory powers pursuant to the Statutory Authorities Act. With respect, that's correct, but not the point. There's then reference to Thornhill, which I'll come back to. But the citation from Lord Diplock's judgment in Thornhill doesn't take the matter any further or contradict anything which the Attorney General argued, because Thornhill, one sees public authority must be understood as embracing local as well as central authorities and including any individual officer who exercises executive functions of a public nature. Indeed, the very nature of the executive functions, which it is the duty of police officers to perform, is likely in practice to involve the commonest risk of contravention of an individual's rights through overzealousness in carrying out those duties. Oh, my Lord, the case against a police officer was perhaps not very similar to the present situation, but in any event, that case would have had to have been brought nowadays against the state as by virtue of the deeming provision which your lordships have seen. But it is quite a different situation from the one with which one is dealing, and indeed doesn't detract in any way from the broader definition that was given in Maharaj. The SASC paragraph 9 performs executive functions in the course of which it may infringe fundamental rights and freedoms, as the appellant alleges. The trial judge correctly, in my view, identified the powers conferred on the SASC by the Act as being, by the Statutory Authorities Act, as being similar to those bestowed on the Public Service Commission by the Constitution. He correctly noticed that the purpose of such commissions was to insulate members of the civil, teaching and police service from political influence exercised directly upon them by the government of the day. And then the quotations from Thomas is referred to. And the means adopted was to vest in autonomous commissions to the exclusion of any other person or authority power to make appointments, transfers, promotions. As the judge recognised correctly again, in my view, these autonomous commissions are nonetheless public authorities. Well, my Lord, it's accepted in part of the agreed statement of facts that we're dealing with a public authority here. But what is not accepted is whether that public authority is the state.
Where did the judge identify the SASCS's powers as similar to the PSC powers?
The judgment begins at 192.
I know. I mean, you refer to this also in your...
Paragraph 17, page
17.
199.
Yes.
Yeah. But actually, I mean, that rather muddies the waters, doesn't it? Because the truth is that, I mean, on your case, and one readily understands it, actually, there's all the difference in the world between the SASC and the other body, which is explicitly under Section 3 of the Constitution, to be deemed to be proceedings against the state.
Well, yes. Well, my Lord, so far as the judge thought it would be a good thing, if you like, or he based his judgment on the notion that the SASC should be kept entirely independent. The Court of Appeal rather agreed with that, because one sees at page on the next page of their judgment, at paragraph 50, they say, I make no criticism of the judge because it is a noble ideal for which he was striving. But they said that the law simply couldn't be read like that. But Lord, I respect it does. It is not necessary to my argument at all that the SASC has broad similarities in the sense that it is independently responsible for hiring and firing, among other things.
And you don't place a great deal of weight on the policy arguments, which seem to have featured quite large in the courts below.
So which arguments?
The policy arguments. You've seen quite a lot of discussion, as you said, as to whether it was a good thing.
Well, no, my Lord, well, we say it is a good thing for the right party to be before the court. But whether that's a question of policy or just what we say is in fact the law.
Well, it's a pure point of construction. I mean, the fact is that Public Service Commission, Police Service Commission, Teacher Service Commission, there isn't that distancing. You've got to sue the attorney.
Yes. And we have also, and I don't lay a great deal of stress on it, drawn a parallel between the position here between the core public authorities and other public authorities. But it isn't necessary to my argument. But
I didn't find that clarified the position.
I'm afraid it appealed to me when I was drafting the case, and it doesn't appeal to me quite so much now, but that sometimes happens. But my Lord, the problem has of who to sue has emerged in the past in the Caribbean, and it's not quite right with respect for the Court of Appeal to say that from time immemorial such proceedings have only been brought against the Attorney General. In fact, the problem first appears to have reared its head so far as this board is concerned in a case involving judicial review, which I've included in the bundle at Divider 16. It's a case called the Minister of Foreign Affairs, Trade and Industry, Vehicle and Supplies Limited, and another. And it was an appeal from Jamaica in 1991.
But I mean, unless it concerns more or less identical statutory provisions to those that we've got to deal with, why is it going to help?
My Lord, it does concern some more or less identical statutory provisions. Not identical, but I don't suggest that it will be the clue to the case. But my Lord, I'd be a little unhappy if your Lordship didn't see this line of authority before you decided the matter. It's very short to develop, I think. Lord, it's, I can take you to very short passages in the case, which involved discrimination in relation to the supply of motor vehicles, I think. Lord, the point which is being considered is whether or not what is involved in the concept of civil proceedings for the purposes of the statutory, the State Liability Proceedings Act, the SLPA. And Lord, the equivalent statute in Jamaica was the Crown Proceedings Act, and it was held by the board, as one sees on page 551 of the report in the headnote, that proceedings for judicial review of the minister's exercise of statutory powers are not civil proceedings against the Crown within the Crown Proceedings Act. So the action was properly brought against the minister rather than an Attorney General, because the point had been taken somewhat similarly that the only way you could do this, because it was a claim against the state, in effect a claim against the state, was to sue the Attorney General. My Lord, at page 554, you see the argument which was brought against the that was minister's contention, an application for leave to apply for an order for certiorari or prohibition in respect of ministerial decision was a proceeding against the Crown, to which the only proper party was the Attorney General. So the proceedings before Mr. Justice Clark were misconceived. That argument rested on the provisions of the Crown Proceedings Act of Jamaica, section 13 of which expressly provides that civil proceedings against the Crown shall be instituted against the Attorney General. The Act, however, contains in section 18 a restrictive definition of civil proceedings, and the Court was unanimous in holding that the proceedings from which the appeal arises were not civil proceedings within the Act. There was thus no statutory requirement rendering the Attorney General either a necessary or a proper party.
That doesn't deal with the question whether it's the state or it deals with the nature of proceedings. So it doesn't really bear on this point at all.
Well, my Lord, insofar as what the next case I was going to show your Lordship, Gary, is a decision from Grenada, and it's a divider 17, but and it's really, I could perhaps, if one looks at paragraph 21, you'll see the point. If there is any relevance, it's here. But it's a decision of Lord Bingham, and gave the judgment. In paragraph 21, since the expression civil proceedings probably excludes what would now be called applications for judicial review, it must be highly questionable whether it includes claims for constitutional redress, which the draftsmen in the United Kingdom in 1947 and Grenada in 1959 could not have contemplated, and which may fairly be regarded as sui generis. And Lord, the point has very recently been taken up, and well, perhaps on the way, there was a case called Durity, which was decided by your Lordship's board, which was under divider 18, in which it was held that the Civil Liability and Proceedings Act, State Liability and Proceedings Act, the provisions for limitation of action did not apply to constitutional claims, so that part of the Act didn't apply. But I thought your Lordships ought at least to know about a very recent decision of the Court of Appeal in St. Lucia, which does address the question of parties to a claim for constitutional redress. It's called Frederick and the Controller of Customs and the Attorney General.
Where's that?
It's under Divider 23 in the one. The judgment was only handed down on July the 6th this year. The situation arose in a quite different way, in that the claimants filed a claim form against the Controller of Customs and the Attorney General, and then attempted to enter judgment on the basis that the Attorney General failed to file an appropriate acknowledgement of service. If one looks at the holding, see that the Crown Proceedings Act, the equivalent of the State Liability Proceedings Act, is to provide for the institution and maintenance of actions by and against the Crown in respect of liabilities arising in contract, tort, or like actions. The claim does not fall into those classes of civil proceedings, being the nature of a review of the exercise of the power used by a public officer. Such claims for constitutional redress are not civil proceedings for the purpose of the Crown Proceedings Act. The rules effectively don't make any difference in paragraph 2. The claim form has to be served on the Attorney General, as it does here. My Lords, I can take you to the judgment in more detail if you would like me to do so. I really refer to it, I say that the decisions in the Caribbean appear to now to be to the effect that the State Liability and Proceedings Act, insofar as it refers to claims under the Constitution, the definition of civil proceedings does not apply to claims under the Constitution.
Yes, the most relevant passage perhaps is at paragraph 34, isn't it?
Oh, yes. I mean, the claim form must be served, and that is, of course, the result of Section 13 of the Supreme Court Act in Trinidad and Tobago. But it is, in our respectful submission, something of a nonsense to require the Attorney General to be made a party in a case such as this, which involves the breach of a constitutional right by a public authority with which the Attorney General, the government directly, have nothing to do.
But difficult to deal with this case without knowing whether the legislation was effectively identical. Can you help on that?
Well, I'm just looking to see whether the State Liability and Proceedings Act equivalent, Section 25, which I showed your Lordships, the equivalent is Section 18, subsection 2, which is found in paragraph 23. You see, that is the provision which refers to civil proceedings against the Crown. Well, there doesn't seem to be an equivalent of Section 19, subsection 8 and 9 in any of the other jurisdictions. Constitutional claims are, of course, constitutional rights are in broadly similar terms in all of the Caribbean constitutions. Your Lordship will see the principal argument on which we rely. But I can take you to the cases which were referred to by the courts below. Maharaj, my Lord Mance, I gave the page reference of. That was the case involving the...
Sorry, where are we looking?
It's a divider 13, my Lord. This was the case which, as I say, was relied on both by the judge at first instance and by the Court of Appeal. The relevant paragraph is at page 396, letter G. Read in the light of the recognition that each of the highly diversified rights and freedoms of the individual described in section 1 already existed, it is in their lordships' view clear that the protection afforded was against contravention of those rights or freedoms by the state or by some other public authority endowed by law with coercive powers. This chapter is concerned with public law, not private law. One man's right is another, freedom is another restriction, etc.
And what does that tell you, except that there was a perfect right to go under section 14 of the Constitution?
Well, yes, it envisages a right not being limited to a right against the state itself. In other words, it refers to by some other public authority.
Well, that's your point.
Yes.
Well, that's all.
Involved in non-sequitur.
Exactly.
And that's the end of the case.
Well, my Lord, if that's right, yes, my Lord.
But it's all necessarily implicit in section 19 of the State Liability and Proceedings Act.
Yeah. Well, my Lord, that is, say that the learned judge, so to speak, took the point that the Court of Appeal, in the short paragraph I've referred to, we say it fell into a demonstrable mistake. Well, the case of Thornhill doesn't, I think, take matters any further. That was the case involving the police officer, or the police. It involved not directing persons' attention to their right to a lawyer. And it's at the relevant paragraph is page 74A to C.
What you want us to look at, Thornhill? Where's this?
It's under divider 14.
Page what?
Page 74, the last page of the report. It's really the passages between B and C. In this context, public authority must be understood as embracing local as well as central authorities and including any individual officer who exercises executive functions of a public nature. Indeed, the very nature of the executive functions which the duty of police officers to perform is likely in practice to involve the commonest risk of contravention. But that again envisages public authority as a word of a wider description than simply the state. Lord, the case of Thomas, which was referred to at length by the judge, my Lord Brown referred to as somewhat muddying the waters, is at divider 15. I've already shown your lordships that the Court of Appeal appeared to accept the judge's point that it was desirable that insofar as possible that the Commission should be treated as outside the government. And Lord, the same point is made in a local case, which is at divider 22, but since it's exactly the same point, I won't take you to that, my Lord. I would very briefly ask you to look at a local case at first instance called Box Hill and the Port Authority, because it's an example of what we say was a correct application of the law in Trinidad and Tobago. It's a divider 21, and it's a decision of Mr. Justice Abood at first instance. He was faced with a comparable situation. But in paragraph 1, you'll see that the application was made under section 4 of the 4D of the Constitution, which is the same section as we have here, and the applicants were not promoted when they said that they were being discriminated against as a result. In paragraph 2 on the next page, you'll see that the respondent, the Port Authority, filed a notice of intended application to have the motion struck out. It said the complaints arose in private and not public law, as the matters did not constitute state action, and further, there was an alternative remedy. Notice of the application was served on the Attorney General in the course of the proceedings, but State Counsel did not attend, save for one pre-trial hearing. If I take you on to paragraph...
Sorry, so there, the section 14 proceeding was named the Port Authority. Yes. Here, mistakenly, you say, they named the Attorney General.
Yeah.
And there, so there was the Port Authority trying to have it set aside.
Yes.
Yeah.
The first question the judge asked himself at page 8 of the judgment, in paragraph 15, was whether the relief did arise in private or public law. The respondent saying that it wasn't a public authority or an agent of the state. And so only private issues arose. The judge developed the question by saying in paragraph 18, in determining whether the relief being sought arises in private or public law, two questions must be asked. One, whether the respondent is a public authority, and B, whether the acts complained of by the applicant are public acts or functions sufficient to validate an application under section 14 of the Constitution.
There the question was there actually any cause of action under section 14? Was it something which nobody questions that there's a cause of action here under section 14?
Well, that's right, my lord.
The only question is who's to be the proper defendant?
Yes. And Lord, he found, Lord, the paragraph 27 that the respondent was a public authority, and that's accepted here. Paragraph 35 he said this: the heart of the complaint is unequal treatment. The Constitution provides a clear statutory underpinning to such a complaint. Constitutional rights are substantive statutory rights. A better statutory underpinning could not be constructed. The right not to be treated unequally cannot be said to be grounded in commercial or contractual obligations, even though the breach is said to originate out of a contract. It is a right that originates, or to put it more correctly, which is declared as a pre-existing right in the body of the Constitution.
Most you get in this case is that if the Court of Appeals is right in the present case, the proceedings in this case ought to, in box the law, to be brought against the Attorney General.
Absolutely.
Yes.
But let's say
Well,
I don't see...
well, yes.
That wasn't the issue. The issue was whether there was a cause of action or not.
Absolutely.
Well, my lord, that was, yes, that was, yes, so the issue did boil down to whether it was a public authority, which is accepted in this case, and whether it was a public law function, which is, again, I think, accepted in this case.
One point they weren't taking was, well, you shouldn't have sued us anyway. The only person you could properly sue was the Attorney General.
My lord, yes. Well, my lord, I hesitate to take you any more of the judgment in the circumstances. The only other point that was made was that well, my lord, I think perhaps the only point was he reminded himself that Section 4D of the Constitution, which is where the complaint was made, is in respect of unequal treatment by a public authority, which, so to speak, ties in the constitutional breach with the particular matter. Well, my Lords, the only other matter that I was going to mention, since I think your Lordship has our arguments, was a matter which was raised by my learned friend in his case, which was that really we were dealing with a matter of procedure which ought to be left to the local courts. But my Lord, we say that's simply wrong. This isn't a matter of procedure at all. It's a matter of who was the correct defendant, which is a substantive matter, and that the self-denying ordinance of not, so to speak, interfering with discretionary matters as to procedure really doesn't come into it. My Lords, those are our submissions.
Yes, thank you very much. Stephen.
My Lords, may I take your Lordships back to the Statutory Authorities Act, Chapter 2401, so that we can see what it is, what creature we're dealing with. It's tab 4.
Tab 5.
Sorry, what are we looking at?
I think it's tab,
Tab 4.
well, in my bundle, it's tab 4.
Yes.
Now, in Trinidad and Tobago, the executive authority of the state is vested in the President. By this act, Parliament vested in the President the power to appoint the Statutory Authorities Service Commission. It was similar to the Public Service Commission in that Section 5 gave it the power of appointment, removal, and discipline of officers who were employed by these statutory authorities. Now, it is not incorporated. It's not a corporate body. The members are appointed under Section 4, but they're not given a corporate status. I would have thought, my Lords, in the circumstances, that if one had to sue that commission, you'd have to sue the individual members of the commission. It's not a corporate body. Parliament didn't give it a corporate status. It's an unincorporated body. It's appointed by the President. The members are paid out of the consolidated fund. In every sense, it is, in our submission, an organ or instrumentality of the central government. It is clothed with functions of appointment, removal, and discipline over persons employed by statutory authorities, but it is the very essence of it is that it's appointed by the President, financed by the state, to do the functions set out in 5. So, if it's an organ or instrumentality of the state, then its actions are state actions, and actions against the state have to be taken according to Section 76 of the Constitution against the Attorney General.
There's nothing about its financing in the Act, is there? No. There's nothing about the financing in the Act, is there?
No.
Sorry.
No.
There is, in Section 22, there's a provision about parties to a dispute, which is not one I quite understand, though. But
Section 22.
Section 22, the purposes of this Act, the parties to a dispute.
Shall be
see
the
the chief personnel officer and the appropriate recognised association in any dispute. But that's, I think,
that's an industrial dispute.
in an industrial dispute.
Industrial dispute. And it's to be dealt with under the Industrial Relations Act. And that's under the Industrial Code, as Section 23 clearly shows. If there is a dispute between the officers and the statutory authority which employs them, then that is resolved by the Industrial Code, Sections 22 and 23.
The personnel organisation is different, is it? Completely different from the Statutory Authorities Services Commission?
Yes.
It's personal, it's the things established by section 14.
Yes, and under section 14.2, the Commission has powers of appointment in relation to that personnel organisation. It shall comprise a chief personnel officer, whose office shall be an office in the civil service, and such other officers and servants, whether members of the civil service or not, as the Commission may consider necessary to appoint. That personnel organisation deals with matters relating to the welfare of the servants in those statutory authorities. 22 and 23 are.
I mean, the President appoints by order, declares that this that any statutory authority or any specified class is subject to the provisions of the Act.
Yes.
So the President sets up this commission, and then he also declares the authorities to which it applies. Is that,
Yes, indeed, by order. And this NLCB, this National Lotteries Control
is one
Board,
of those.
So the main argument for the respondent in this case, my lords, is that this body set up by this Act is a state organ or instrumentality, and that its actions are actions of the state, stricto sensu, when it appoints, removes, and disciplines. So that section 76 of the Constitution reaches its actions. And the Constitution is the supreme law. Nothing could be inconsistent with it. And in the Constitution, in section 76, there is a simple dichotomy. The constitutional dichotomy, my lords, is between civil proceedings and criminal proceedings. There is no proceeding sui generis, which section 76 contemplates. Section 76 has a dichotomy. If a thing is not criminal, it's civil. Section 76 appears in the same constitution that has section 14. And I would have thought, my lords, that section 14 proceedings, in terms of section 76, are civil proceedings. So the issue is whether they're correctly taken against the state, because the Commission is a state instrumentality.
But section 14.3 says in terms that the State Liability and Proceedings Act has effect for the purpose of proceedings under section 14.
14.3.
14.3, absolutely.
Yeah.
So we've got to look at the State Liability and Proceedings Act. That's what governs it, isn't it?
But 14.3 of the Constitution, when it says the State Liability and Proceedings Act shall apply for purposes of that section 14,
Well, that's what we've got.
then they too will say that civil proceedings are to be taken against the state, against the Attorney General. Civil proceedings against the state are to be taken against the Attorney General.
What says that? I'm sorry. The State Liability and Proceedings Act, of course, in 19.2 says that, but I mean, it defines civil proceedings. It says that it doesn't include proceedings, analogous to proceedings on the Crown side of the Queen's Bench Division in England, for a start. I mean, I'm a little unclear, Sir Fenton. Am I aberrating or...
Sorry, where is this? This is...
I mean, you're, as I understand it, relying on section 19.2 of that act.
Yes. Subject to this, yes.
You're also trying to rely on the fact that these are civil proceedings. The civil proceedings wouldn't seem to include a section 14. Challenge. And that aside, I mean, why aren't this body, this Statutory Authorisation Services Commission, why aren't they an authority, although not, of course, an authority within the definition of the Act?
Well, there would be an authority, must be an authority, there must be a public authority too. But the question is, what function and on whose behalf do they carry out their functions? The state must carry out its duties, whatever, or functions, whatever they may be, by its staff, its servants, the organs it creates. There is no question, my lords, that Parliament had the right to create a statutory authorities service commission to deal with the appointment, removal, and discipline of these statutory officers, of these statutory authority officers. Having done that, this commission stands on its own. It's appointed by the President. Its members are paid from the consolidated fund, like a truly government body with a statutory function of appointment, removal, and discipline. That's what it is. Because that is its nature, we submit, my lords, that it is the state. It is the state. It's not a statutory authority. It can appoint, remove, and discipline the staff of the statutory authority. But it's not one of the statutory authorities whom the President can designate by an order. It stands by itself in terms of this Act. It's not like the National Lotteries Control Board. It can appoint, remove, and discipline the staff of that board. But it's different in its character. It stands on its own. It's a statutory body created by the President with a particular purpose and financed from the consolidated fund. It is an organ of the government, an organ of the executive. It has executive functions. In the separation of powers, my lords, it carries out executive functions. in the separation of powers between executive, legislative, and judicial. It performs executive functions, state executive functions.
I mean, it's a legal body, is it not? It's got a legal personality.
Well, normally we will expect that the personality would be corporate, but it isn't.
No, but it's an unincorporated statutory body. No,
Well, you could bring an action against the cabinet. You say it's rather similar.
Yes. Yes, my lord, yes. Because the cabinet is not an incorporated body. It's a cabinet. It's a body of members, body of ministers who make up the cabinet. The Attorney General has to be one. The Prime Minister has to be one.
what legislation determines who the cabinet is?
The Constitution, Cabinet Section 75, my lords may have it there. Let's see.
It's a tab one.
It's tab 1.
No.
It's just above the one saying that it's above 76.
Yeah.
There shall be a cabinet for Trinidad and Tobago, which shall have general. The cabinet shall consist of the Prime Minister and such number of other ministers, of whom one shall be the Attorney General, appointed in accordance with the provisions of Section 76, as the Prime Minister may consider appropriate. So that's a constitutional body. It isn't given a corporate status. And the Statutory Authorities Service Commission is something like that, but this time created by Parliament.
Only funds are appropriated to it by the Appropriation Acts. Would that be right? I mean, Parliament, it must get funds from somewhere. Because there is a reference in the schedule to the purposes for which its funds shall be applicable. So Parliament must provide funds to it, isn't that right?
Mm-hmm. Yes.
Presumably under Appropriation Act. I mean, the schedule.
Well, my lords, the Parliament has just
Association registered under.
provided for the appointment of the Commission, provided for their function, and has said nothing more.
I'm sorry, I've misread that.
If they were to be sued, sorry, my lord.
I know my friend points out that that schedule actually applies to an association registered under the Act, so it doesn't apply. I beg your pardon.
How do we get associations registered under this Act?
By the President in terms of Section 3.
Section 3, is it?
I think it is. Section 3. Isn't it? That's an authority. No, it's not.
Isn't it under sections, 24 onwards? That's dealing with associations.
Yes, yes.
24.
Yes,
But I mean, I find it difficult to see that the Commission doesn't have sufficient legal existence to sue or be sued. It's created, established under Section 4. It does things in its own name. If it did them wrong, on the face of it, somebody could complain by suit directed to the Commission. I mean, you say, well, maybe it should be to the members of the Commission.
Well, in judicial review proceedings, I think that they can be made a party.
Yes.
There's no list between the parties. But there's no question about that, my lord, that they can, in certain circumstances, be proper parties to litigation.
Yes. And your whole argument is that because theirs is a public function, in these circumstances, they are to be regarded as the state.
Yes.
But why does that follow? Is everything which performs a public function part of the state? I mean, is the local authority, is every conceivable person who's a body which owes its existence to the state and is fulfilling a public function part of the state in your definition?
I think the answer to that, my lord, is what is its function in relation to the state itself? In relation to the state itself, what is its position? We know what the state is. We know the state must act through its servants and agents and its organs and its instrumentalities. What is the relationship between this creature set up by Section 4 of the Statutory Authorities Act and the state?
It's intended to act independently, isn't it? I mean, certainly when you come to promoting, removing, exercising disciplinary transfer, disciplinary control, it would be quite wrong if it simply acted at the behest of the executive, wouldn't it?
No, it was intended that it should act on its own,
Yes.
independently.
So
But that doesn't prevent it from being an organ of the executive. The fact that it acts independently does not prevent it, my lord, from being an organ of the executive. And I think that that is what has happened in this case. That is why in our submission the error came about. Because it is an independent, it functions independently. It cannot be interfered with by the politicians, as it were. It is still an executive organ of the state, appointed by the president, with a function which Parliament has set up. It's appointed by the supreme executive authority of the state. My lords have
why was it necessary to have the deeming provision in respect of the constitutional commissions? On your argument,
that is because what happened was that there was a case heard by the board in which three members were appointed to constitute a tribunal in relation to discipline of a judge. And the orders for costs were made by the board against the parties who included these three retired judges. And the state didn't pay the costs, so the person in whose favor the cost order was made sought to levy execution against the individual members of the tribunal. The private carried out against them personally. And then this amendment was rushed through the Parliament to say that these people would be deemed to be servants of the state. That happened as a result of the Rees and Crane case. It's mentioned in the proceedings here. Now, obviously, the Statutory Authority Service Commission wasn't in contemplation at the time, so that wasn't put in.
Sorry,
so
this
we left
body...
back on general principles. And your lordships will notice that a servant of the state in section 2.2, subsection 2 of the State Liability and Proceedings Act, a servant of the state can include a statutory corporation. The definition of servant at F. Any officer, employee, or servant of a statutory corporation could be a servant in relation to the state.
Sorry, servant, I see. Sorry, I'm a bit lost. The deeming I had understood my lord was referring to as the 1908 deeming in respect of these Section 3 service commissions.
Yes. Now, my lords, I would wish to submit about that this. Without that amendment, these service commissions created by the Constitution, the Judicial and Legal Service Commission, the Public Service Commission, Police Service Commission, all these constitutional commissions are part of the executive. They are part of the executive. Although they function independently, they are part of the executive in the doctrine of separation of powers. They are part of the executive. Although they are independent commissions, they are part of the executive. It is true that there can't be interference with them. They're supposed to act independently and not to take directions and not to be under control of any other person or authority. But they are part of the executive.
But they are indeed deemed, proceedings against them are deemed indeed to be proceedings against the state, and you've got to sue the Attorney General under Section 14. But that's not the position with our particular statutory body.
That is so, my lord, that's so.
And that, I understood that was...
So we're back on the general principle. Suppose the amendment to the State Liability and Proceedings Act had not been passed when execution was threatened against these members of the tribunal. Suppose this amendment had not been passed. What would have been the position of these commission members in constitutional law? My submission is that without that amendment, they would have been part of the executive.
I'm sorry, I don't know the case you're referring, but are you saying that they were Judicial and Legal Services Commission? I mean, why does this deeming provision introduced by amendment help in that case? Were they one of these service commissions?
That was in order to give them immunity from the legal process that was threatened. But I would have thought...
They were presumably, I'm sorry to interrupt, but they were presumably, a disciplinary tribunal appointed by the Judicial and Legal Service Commission.
Yes.
Were the members of the disciplinary tribunal actually members of the Judicial and Legal Service Commission? That slightly surprises me, but it may be the case. They didn't appoint independent retired judges to hold the disciplinary proceedings.
I think they were a separate body appointed. I don't think...
How are they protected by the amendment?
Exactly.
Oh, they were protected by the amendment against personal execution for the costs, which is what happened in Trinidad and Tobago that led to that amendment.
Well, they're only protected if they're members of an authority established by the Constitution. An authority means here, the Judicial and Legal Service Commission, and I think you just told us that they weren't, you thought, members of the Judicial and Legal Service Commission.
Well, we're trying to get it, yes.
Yes. All right.
We're trying to get the reason very clear. Yeah.
I mean, I presume that the implication, therefore, of this kind of amendment would be, if Mr. Guthrie is right, then the members of the commission would be personally liable without having any indemnity from the state. Is that right?
But equally, on your case, in the, I mean, so far as one understands the previous proceedings, in the previous proceedings, the proceedings should have been brought not against the 3 retired judges, they should have been brought against the Attorney General.
I would have thought so, my lord, yes. And indeed, there were 2 sets of proceedings consolidated, I think, in that case, in the Reason Crane case, there were 2 sets of proceedings, and I think one was brought against the Attorney General.
One was a judicial review
And one was a judicial review, and they were consolidated and heard together.
But surely the question of whether someone in public life who gets sued is entitled to an indemnity from public funds is a quite different question from who are the proper parties to litigation, is it not?
Yes, that could be so, my lord. That could be so. But it doesn't obviate the question of whether, because of their actions, the state could be sued in the first place.
If we get hold of the case, it may or may not cast light on that.
Mr. Fenton, I mean, is it your case that anybody who, against whom proceedings are properly brought under Section 14 must, so to speak, be sued in the name of the attorney? That's, I rather understood that.
I think, no. I think that we have to see whether it's a function of the executive or of the legislature or of the judiciary that is being performed, in the course of which the fundamental right is contravened. I think that is the way I would like to put it.
So you decide whether it's the executive,
Judiciary or the legislature. In the cases where we challenge the constitutionality of legislation, we bring the case against the Attorney General. In Maharaj, it was a judge who had committed a barrister for contempt. We brought the case against the Attorney General.
So you're saying whichever it is, you have to bring it against the Attorney General?
Well, it comes back to the same thing.
No, but I rather read paragraph 5 of the Court of Appeal's judgment as saying, in effect, anything that anytime you can bring proceedings under Section 14, under Section 19 of the other Act, the State Liability and Proceedings Act, you've got to bring them against the Attorney General. And I understand you to be saying the same thing now. Is that what you're saying?
Well, the Port Authority, if they are acting as agents of the state can be sued.
I'm sorry. What about that case? I mean, should they have been taking the point that if and insofar as there was any liability under Section 14, it was against the state and therefore they weren't the proper respondent, it should have been the Attorney General. Why didn't they say that?
The question is, need they have done, my lord? Need they have done? Need they have taken that point? That was a statutory corporation, the Port Authority. They were doing things, and it was alleged in that Box Hill case that they had violated the equal treatment provision of the Constitution, and they were sued. The constitutional motion was brought against them.
Was that all right?
And I would have thought that if they were acting on behalf of the state, it could have been brought against the Attorney General.
But if they weren't acting on behalf of the state, was there a Section 14 case against them?
No, I don't think they were acting on behalf of the state. They were a corporation established to run the port. And while they might have been wholly owned by the state, they were not the state.
So it was perfectly proper to sue them under Section 14.
Yeah.
Is that right?
I would have thought, my lords, that if they were sued, if the Attorney General had been sued on an allegation that that statutory corporation was acting as an agent of the state itself, the Attorney General couldn't complain.
Well, that's not quite the question. I mean, could the body itself have said, you're not allowed to sue me, you've got to sue the Attorney General? You've got to make your complaint about me in Section 14 proceedings against the Attorney General. Could they have said that? Because that's what you're saying.
Yes, they could have said that.
But they didn't.
No. They allowed the case to go at first instance as if the statutory corporation would have been bound by the fundamental rights guarantees. So the case was decided on that basis. In the end, the judge found that the guarantees had not been breached, and the case was dismissed, but that's how it went.
So you are saying, I think, that any Section 14 proceedings has to be brought against the Attorney General?
I don't know. No.
Well,
suppose, my lord, suppose.
Yeah.
Suppose the mayor and city council of San Fernando, a statutory corporation, were to make bylaws, and those bylaws infringe the property rights provisions of the Constitution. Surely the proceeding can be taken against the mayor and city council. Then we serve it under Section 13 on the Attorney General.
And that's because the proceedings are not brought against the state?
No.
Is that it?
No. They're brought against the mayor and city council that made the bylaws. Bylaws having the force of law, because they have powers under the statute to make bylaws. They can affect buildings, property, lots of property rights. Suppose they infringed in making the bylaw. Then my submission is that the proceedings could be brought against them under Section 14 for a contravention of the fundamental rights guarantees. And that would be a proper thing. The Attorney General will have to be served under Section 13 of the Supreme Court of Judicature Act.
Well, what's the test for distinguishing that situation from the present, where the Commission is clearly intended to act independently and in some cases judicially exercising disciplinary control?
Well, that would follow, my lord, from what Lord Diplock was saying in Maharaj, where he spoke of the state and some other authority with coercive powers. You see, the mayor and city council can pass bylaws and impose sanctions. It has coercive powers.
Yes.
And if we follow what Lord Diplock said in Maharaj, they become liable to be sued.
No, I see that. I mean, you put the mayor and city council in the category of other public authority. You don't put the commission in that category, but I want to know why. What is the test you're applying to decide which category the commission belongs to?
Or the test is whether it is something which can be attributed to the central executive government rather than the local government body, the mayor and city council, as it were. That's the test I use, my lord.
I mean, presumably there are lots of statutory bodies. I mean, you know, over here we had the Criminal Injuries Compensation Board in days past, and they were obviously a statutory body. But, I mean, does that sort of body, is that an instrumentality, an organ of central government?
No, no.
Well, why is...
Well, if its functions are central government functions, it's an organ or instrument.
How do you know if it's a central government function? I mean, how do we know? Why do we suppose that this particular commission is discharging what you call a central government function?
Because we look at how it begins. How does this creature come into being? The president, in whom is vested the executive authority of the state, appoints this body.
No, the Act creates it and the President appoints its members.
Yes.
So it says creature of the legislature, actually.
Yes.
And what can it enter into contracts of employment, the commission itself?
I don't think so.
No.
All it can do is appoint, remove, and discipline.
Where does it say there?
What it can do is, under Section 6, with the consent of the Prime Minister, and I suppose that may assist you a bit, by regulations or otherwise, regulate its own procedure, including the procedure of appointment, promotion, transfer, and removal from office of officers of statutory authorities and the exercise of disciplinary control over such officers. So, for example, we find the regulations tucked away in divided 5, and Regulation 110 provides for penalties of dismissal and so on and so forth.
These are other authorities' officers.
Yes.
But it has its own officers in clerical and secretarial classes under Section 12.
Well, Section 6 is intended to enable regulations to be made so that the functions under Section 5 can be performed. And that is why, and they are like the regulations for the public service made with the consent of the Prime Minister. But these regulations only relate to the staff over whom they have powers of appointment, removal, and discipline.
Not their own staff.
Not their own staff. It's the staff of the other. It's the staff of the statutory authorities, which they are appointed to supervise or control. Whatever.
Section 3.2 talks about the staff of the Commission. Every person appointed a member of the staff of the Commission
Section 3.2.
shall, as soon as possible after appointment, take the oath or make the affirmation. So,
Yeah, it's Regulation 3.2.
in the regulations, 5, Section 3.2.
And haven't we got some equivalent body here who, in this country?
I think it is, for instance, the Judicial Appointments Commission.
Well,
which
no,
has
but
staff.
What Civil Service Commissioner or
I
something?
mean, who is it who, for example, appoints the members of the Judicial
Yeah,
Appointments
the
Commission?
Civil Service, isn't there a Civil Service Commissioner?
There's express statutory provision for this.
we? I mean, we've got... Isn't Janet Gaynor or somebody else?
In section 4 of the Statutory Authorities Act, they speak of the members of the commission, but they don't speak of the appointments, except section 9 says that there may be transfers of staff and so on. But the commission must have staff.
It's possible that section 5(1) is wide enough to cover the Commission's own officers, but it's quite clear from the regulations that they're intended to have staff.
But that's section 5(1).
As a matter of interest, I mean, does our commission have control over the appointment and disciplining of people in the service commissions? Yeah. The ones that are listed in section 3 of the Constitution?
Are they deemed to this statutory?
This is defined in the regulations.
Very much.
My lords, I still don't see anything about the officers of the commission itself.
Previous page.
Well, it may be that the central government provides them with staff. I don't know how they operate, but where we speak of officer in the regulations, we mean the officers in the statutory authority itself. Officer means a person who's appointed to hold or to act in an office in the service of a statutory authority and whose remuneration is paid on a monthly basis. That's the definition in Regulation 2 of the Statutory Authorities Service Commission regulations. So these regulations apply only in relation to the persons who are actually employed in the statutory authorities. So that the Commission itself must have its staff from somewhere else, and I can only think of the central government providing the staff.
But if one of the staff wants to sue the commission, they've got to sue the attorney, have they?
It's not easy to see, well, it depends on the basis of the action. Well, it's going to be an action in public law, most certainly, isn't it?
Well, if it's a private law action, why doesn't section 76 of the Constitution? I mean, is it legal proceedings against the state? What's the position, Mr. Fenton? I mean, if one of the, as I say, somebody employed by the Commission wants to sue the Commission, they, for, I don't know, unpaid, whatever it is, or I don't know, perfectly ordinary claim, private law claim, have they got to sue the Attorney General by virtue of section 76(2) of the Constitution?
No, it's not going to be done except on a case-by-case basis, I would have thought. To put forward a general principle of when the Attorney General ought to be sued or can be sued, I can think of no other situation except where you can say that what is complained about is an action of the state itself.
Can I just ask, I mean, we were shown some authorities by Mr. Guthrie which indicated that civil proceedings, at least in those constitutions, didn't include judicial review, or probably didn't. I mean, one was a decision of the board which said probably not judicial review not included, but if it is, doesn't matter. So it's not clear that Section 76(2) deals with Section 14 claims at all. When you go to the State Liability and Proceedings Act, which is framed differently and refers to simply proceedings by or against the state, I wonder whether that's dealing with judicial review proceedings at all either. Isn't it dealing with ordinary, the whole of the thing is dealing with ordinary types of tort and contract claim, isn't it? And it's not dealing with public law, or am I wrong?
No, but I mean, Section 14(3) of the Constitution itself introduces the State Liability and Proceedings Act 1966.
See, that Section 14(3) incorporates that whole act by reference into Section 14.
In fact, it's there at all, suggests that if it weren't there, it wouldn't be covered.
I think that's right.
I think that's absolutely right.
Yeah.
The Crime Proceedings Act doesn't apply to.
What?
The Crime Proceedings Act doesn't apply to,
No.
to judicial.
But maybe Section 14(3) is a special provision which is dealing with the unusual situation where in ordinary civil proceedings a public law point is raised. It's got to be referred to the High Court.
It certainly does incorporate by reference the whole act.
Yes.
It comes out to 14.1.
Lord,
Yeah.
my friend Mr. Ramlogan.
Mr. Ramsden?
Hello. Well, there are some practical considerations as to how these constitutional motions and this issue has been dealt with in our jurisdiction, which I wish to bring to the board's attention. For example, the Port Authority case. The reason one would sue the Port Authority in a discrimination action direct and the point might not arise for consideration is because the Port Authority is created and established by an Act of Parliament which normally provides that it is a body corporate which can sue and be sued in its own name. Generally speaking, you would find that when that provision exists in our laws, the body is clothed with the juridical and legal character to sue and be sued in its own name, and that is expressly provided for by Parliament. So that insofar as Section 4D of the Constitution creates a right to equality of treatment from a public authority in the exercise of its functions, and insofar as that public authority might have a separate legal personality that is capable of being sued in its own right, then you can sue under Section 4D. I might not for myself necessarily stretch the submission to say any and or all public authorities are necessarily part of the bosom of the state or part of the executive, so that there would be a generalized principle that regardless of the public authority, that you must sue the Attorney General. What happened in the Port Authority case is not something I for myself, can see that should be faulted. But what I do see is that on the facts of this case, where Parliament did not clothe the Statutory Authority Service Commission with a separate legal personality that is capable of being sued or can sue in its own right, with that kind of personality, I don't think that it would be right to sue the Statutory Authority Service Commission for discrimination. The correct party had to be the Attorney General. I say this for practical as well as legal reasons, my lord. The recent Crane case, which came before this board, came firstly by way of judicial review, and then there was a consolidation of a constitutional motion. Now, in judicial review proceedings, when the costs are awarded, it has always been a point of contention that the budget that pays the legal costs has to come from the Attorney General's pockets. And that recent Crane case, as well as others, exhibited that tension and the financial strain that created on the relationship. And one has to understand and appreciate the principle by reference to the converse argument. If the Attorney General and the state is submitting that these statutory commissions or these service commissions can be sued in their own right, or alternatively and conversely, sue in their own right, it begs the question, if the commission sues in its own right and loses a matter, where's the legal costs going to be paid from? As my lord quite rightly noted, the financial provisions are really absent from this act. The guts and heart and lungs as to how this commission will operate on a day-to-day basis with resources and financial considerations is absent because it's a creature of the state. And may I point out that the deeming provision to which we've spent some time on, the deeming provision was, maybe it was hastily done because it clearly did not incorporate all that could be envisaged and all that should have been contemplated. For example, in the Constitution, we also have the Salaries Review Commission. We have the Integrity Commission. These are other constitutional commissions in the same Constitution. My learned friend and I have done many cases against these commissions. And again, the legal representation for the commission is appointed by the Attorney General. It comes from the Solicitor General's office. The costs, if you win, are payable out of the Attorney General's budget. And conversely, if you lose, it's payable directly to the Attorney General and the Consolidated Fund. If you lose, you don't pay the cost to the Commission.
So you would say that if one looked at the Appropriation Act, you wouldn't find any separate provision being made for this Commission. It would just fall within the budget of the Attorney General.
It will, my lord. And even if separate provision was in fact made, it would cover the running day-to-day administrative expenses of the Commission, but you would not find a legal budget. That's the point I'm making. Even if there was a separate budget, because I assume in the draft estimates the Commission would have to say what it costs annually to pay its staff and run its operations. But what you would not find, this is not like the Port Authority operates to make a profit. It's an independent corporate body appointed pursuant to an Act of Parliament, incorporated by an Act of Parliament, that is there to make a profit. It's owned by the state, its shareholder is Corporation Sole, the Minister of Finance. But the point is it's there to make a profit in its own right, and it can hire and fire, it can do as it pleases.
But I don't understand why, if you can have a routine estimate for the Commission, in a year in which the Commission unfortunately incurred legal costs, I can't understand why you wouldn't get an additional estimate.
The problem, Lord, would be how would one... The problem is, Lord, you can't estimate prospectively in a vacuum.
No, but you can retrospectively, in any year
sure,
where an additional cost is incurred, then provision can be made under the Appropriation Acts for...
Well, no, yes, I can see that is entirely possible. As to whether it's practical and whether that's what's been happening in Trinidad and Tobago.
I don't know.
Yeah, but that's not the case. I mean, if that was the case, there would be no need for the deeming provision. You see, and that's really the crux of the matter. You see, my lord, if the public body, for example, let's take the equivalent of we have the regional health authorities, which are the equivalent of the NHS trust or one of the regional health authorities that may exist here. That is established by an act of parliament. It says it's a body corporate which can sue and be sued in its own name. Yes, it's appointed by the executive, but it has an independent legal character and status. So that if, for example, they were to discriminate against someone, under Section 4D, I would have thought that you can sue them directly and do as my learned senior says, which is to give the Attorney General notice of the proceedings pursuant to the Supreme Court Judicature Act.
Mr. Ramlogan, you said a moment ago there were many actions brought against the Salaries Review Commission and the Integrity Commission. Are they sued in their own names?
Yeah, well, these were judicial review proceedings, and with the Integrity Commission is sued in its own name. The Salaries Review Commission is sued in its own name. Yes. And one has to be...
Are they structurally any different from this commission?
Oh, yes, it is, for the simple reason that in judicial review proceedings, it's been decided a long time ago that you would sue the body that is susceptible to judicial review and whose powers you're reviewing.
Yes.
There's no list between the parties, and judicial review is brought eo nomine in the name of the Crown or State.
Yes.
But why is that legitimate? We were looking a moment ago at the constitutional definition of civil proceedings in the Constitution and the references in the State Liability and Proceedings Act to all proceedings, and that act being referred to in the Constitution. Why aren't judicial review proceedings caught by the requirement to sue the Attorney General?
My Lord, because if one looks at Section 14 of the Constitution...
Sorry, isn't the short answer Section 25, subsection 2 of the State Liability Act, which contains a very restrictive definition of civil proceedings?
It may very well be.
And the argument is that Section 14 is necessary. Section 14 is necessary because otherwise you would be caught by Section 25 too.
That is correct. That is correct. May I say, my Lord, that there have been many cases that have come throughout, this full gamut of the legal system in which judicial review proceedings have been recognized as a separate kettle of fish altogether. There's no list between the parties. It's brought eo nomine in the name of the Crown or State. But the whole point is that you want to have the decision maker or the statutory body whose powers you're seeking to judicially review before the court. But as to what happens thereafter in terms of practical administration, who pays legal costs, who provides legal representation, may I make the point, my lords, that all legal representation for the service commissions, including this particular commission, comes from the office of the Attorney General. The counsel is appointed from the Solicitor General's office. A commission does not have the right to select independent counsel. The counsel comes through the office of the Attorney General, through instructions from the Attorney General's office. But the Port Authority, conversely, for example, which is operating to make a profit on its own, it can retain private lawyers from the bar to represent it. But a service commission cannot do that. The representation comes from the Solicitor General and the Attorney General's chambers.
And the employees of the Commission are civil servants appointed by central government.
Yes, indeed. I mean, that is why the definition of officers to which my learned friend Sir Fenton adverted is important, because the definition of officers in the statutory authorities regulations makes it clear. I believe my Lord Mance was saying that Section 5 in the Statutory Authorities Act, the reference to officers there and the reference to power to promote, discipline and remove officers could be construed and is wide enough to include officers of the Statutory Commission. The problem is that in the definition section of the regulations, which is to be found at tab 5, officer is defined as meaning a person who is appointed to hold or to act in an office in the service of a statutory authority and whose remuneration is paid on a monthly basis. So officer in section 5 cannot be so widely stretched so as to be interpreted as meaning and including officers of the statutory authority's service commission. This commission is a very amorphous body. It carries out functions legitimately on behalf of the executive, but it is part of the executive because all it can do is promote discipline, transfer officers of various statutory bodies. That's all it can do. Its juridical character it's almost inchoate, if I may use that term.
It's not a statutory authority itself.
No, it isn't. That's the point.
Why not?
Yes.
Well, my lord, why not?
It falls within the definition of statutory authority, does it not?
Well, my lord, why not? Firstly, because in our laws and experience, when Parliament intended to create a statutory authority that is capable of suit, it normally would provide that for that in the Act itself. All of our Acts of Parliament, where you find an independent body, and that was the intention of the legislature, that provision is expressly contained in the Act itself. And in the absence of such a provision, declaring it to be a body corporate.
No, the definition says whether corporated or unincorporated.
Where is this now? Sorry, beg your pardon?
It's in the definition section of the Statutory Authorities Service Commission regulations, which I thought was what you were looking at.
Right, yes,
It has to be declared by the President to be subject to the provisions of the Act. I mean, has it been?
sorry, my lord.
Under the definition, it has to be not only what the first 4 lines say, but declared by the President to be subject to the provisions of the Act.
Well, yes.
Has it been?
No.
You have an entirely incestuous situation. It's a statutory authority itself.
I believe that conjunctive part with the presidential declaration will pose a problem in terms of seeing the commission in that way. I don't think we need to stretch this and go into all sorts of legal gymnastics about it. It's what the commission was meant to do. It's plain and simple. It was an inchoate body created by the executive, meant to be insulated from direct political control, that will simply exercise powers of discipline, hiring and transfer over these officers who are working in independent statutory authorities that are owned by the state. And the reason for that simply is that these statutory bodies, which have their own independent legal character and can be sued in their own name, there's a fear of political favoritism, victimization, or discrimination. And the way Parliament dealt with that is to simply have this intermediate body known as the Statutory Authorities Service Commission, vested with the sole and exclusive jurisdiction to deal with these matters.
You say it was, if it hadn't been for this act, the disciplining and so on, these would have been an act of the executive of the state, and it doesn't cease to be such, you say, because you interpose this body to do it in a neutral way. Is that
Indeed, my lord. It's tantamount to the alter ego of the state, if I may use that term, but it's just an intermediary that the state has created without vesting it with independent legal and juridical character and status. And if I may answer my lord's previous question about who would an officer sue, the contracts of employment with these service commissions, normally it's done between the permanent secretary in the Ministry of the Attorney General or some other ministry. But you would normally sue whoever your contract of employment is with. And if it's a permanent secretary in the Ministry of the Attorney General or any other ministry, you would sue the Attorney General as representing the state. If, for example, you had a claim in negligence or for damages for breach of contract, that's the person you'd sue. Now, my lord, may I just shift briefly to a different aspect of the case that has not been addressed? And I'd like to do so by taking my lords to page 204 of the record. You will see it, the order made by the learned judge, the trial judge in the High Court, at page 203. The order made was that both parties were of the view that if I agreed with the preliminary point, the proceedings could be amended. Now I pause there because that was an agreed position. In the circumstances, I grant leave to the claimant to amend the proceedings to strike out the Attorney General as a defendant and add the statutory commission. May I take my lords to page 293 of the record? At page 292 at the bottom, 292, 293. Well, at the top, beg your pardon, it's 184 to 185. I keep mixing up the numbers from the top to the bottom. One 185. These were the.
Sorry, are we now looking at the bottom or the top?
Well, 184, 185 at the top. At the bottom is 292, 293.
Thank you.
Sorry.
No.
Right.
Yes.
Well, this is what transpired in the High Court. What I said to the learned judge was that at paragraph 18, in any event, it is submitted that even if the Attorney General is the wrong party, this is an application for administrative orders under the CPR, and the claim cannot be defeated on this basis. The court would simply have to exercise its discretion to grant leave to the claimant to amend and join the appropriate party with consequential amendments. Now, what we submitted both in the High Court and the Court of Appeal is that if the judge felt that the commission should be before the court, it can join the commission. But it would not be right to strike out the Attorney General altogether. That was what we had said the alternative fallback position could and should be. And the reason for advocating that position is simply this. Who will pay Carmel Smith's damages and legal costs if the Attorney General is not made a party to the proceedings? That's the bottom line. In our experience, the fees, the legal costs, and the damages is payable out of the Attorney General's budget. So that unless the Attorney General is a party to the proceedings, the damages order will not bite or bind the state or bind the Attorney General. And that is where the problems arise as to levying on the individual members of the commission and the whole issue, whether it's an unincorporated association, an unincorporated body, and all sorts of things come into play. But the stark reality is if the judge felt, or if a judge feels, that a commission requires or requests separate legal representation, which is unheard of, and they wish to be joined as a party to the proceedings, as an interested party or whatever, then you can make such an order, but you can't, in my respectful submission, strike out the Attorney General in a case where the commission has no juridical independent status of its own, and more importantly, no legal budget of its own to satisfy any relief and remedy that may be awarded by the court. So even if we're wrong, what we're saying is that even if the board is not with us in this appeal, the fallback position, the correct fallback position, even if we're wrong, really ought to have been that the judge could order that the commission be heard as an interested party or be joined as a party to the proceedings. But he could not, in our respectful view, and it was wrong, to strike out the Attorney General altogether and eliminate him as a party to the proceedings for practical and legal and other considerations.
What's the legal basis for keeping him in? If you're wrong about who should be sued.
Well,
the state isn't interested. You're interested in having a state.
Well, I'm glad my Lord focused on legal as opposed to practical, but the legal consideration, if I had to find one, would really have to be located in section 14 of the Constitution. The Constitution and the fundamental rights provisions are predicated on the assumption that it is the state and the Attorney General, really, that will be liable by and large. I mean, primarily, it is an action against the state. Your constitutional rights under our Constitution are not owed to you by any private citizen. A private citizen is free to discriminate in his employment practices if he wants. It is the state that cannot discriminate. So I would have thought I would locate that in squarely in section 14 of the Constitution. And it would be very rare that one would find a constitutional motion alleging a violation of one's fundamental human rights by a state or a state organ without an independent juridical character that can be sued or sue in its own right, and the Attorney General not be a party to those proceedings. It would be rather strange. One can foresee, for example, if the argument is that these commissions have this right to be sued in their own name, what would happen if the commission then took legal action and sued someone in their own right? What then happens if the commission wins that case? To whom is the damages payable? If it loses the action, who pays the legal costs? So if we are saying these commissions can be sued directly under the Constitution, we must also accept that they can also initiate of their own motion and volition legal action of their own.
It's very hard to think of any cause of action that the Commission could have. Could it sue in defamation?
Well, defamation perhaps.
I don't think it could it?
Well, my lord, I can see that we've had, for example, we've had a case recently, for example, where one of the members of a commission, there was an issue with respect to the remuneration and whether a chauffeur allowance, which was provided for, could have been taken directly and not be given to a chauffeur. There are many permutations in the West Indies that can occur, given our unique social and political culture, my lord. But I don't for a moment want to be bound as saying that I can't envisage a case where the Commission would need to take action against another public authority. It can happen, and it may be rare, but it can.
Can I just come to proceedings against the Commission? Because I think you accept that if they were judicial review proceedings,
yes,
they would be brought against the Commission.
Yes, I accept that.
Well, wouldn't you have all the same problems regarding costs?
Well, that is, which is why, my lord, when those problems arose, we had the deeming provision.
Oh, I see that, but it doesn't apply to this Commission. Can I just then pursue that?
Yes.
I mean, you say these proceedings are different. Why? Because they are, you say, are they ordinary civil proceedings? You say they're just a claim.
No, I said these proceedings are located. These proceedings originate and are located. The access is located squarely in Section 14 of the Constitution, and 14.1, which says that you can apply to the High Court for redress.
Yes, but I mean that begs the question against whom. And then we look at Section 76, which only applies to civil proceedings, and I think you accept doesn't apply to judicial review, and maybe it might be said doesn't apply to constitutional proceedings, which is evidently what the board thought might be the case when it opined in Gary. So you then look at the State Liability and Proceedings Act, and you see that that refers to a very narrow definition of civil proceedings. I don't pretend to have fully digested it, but the civil proceedings don't include judicial review. They probably don't include constitutional claims, do they? They seem to include ordinary civil proceedings. But I suppose it might be argued, well, Section 19 isn't confined to civil proceedings, it refers to any proceedings, but I think my Lord's point was that it was implicitly confined to civil proceedings, if I've understood it correctly.
But
I understand that, context.
That's an issue.
I'm lost.
But it's an issue that has been taken for granted before, because the law has, as we know it, has been divided simply into civil and criminal.
Actually, so you say, but I mean, on that logic, judicial proceedings, just fall out? They aren't called by pure as flu.
Well,
constitutional proceedings are civil proceedings.
Well, query whether judicial review is a proceeding in the sense of a suit, bearing in mind that there is authority to suggest there's no list between the parties, there are no real parties before the court in a judicial review application, and all of that.
In this case, it seems to me, couldn't it by judicial review?
Oh, not at all, no. You'd come up with it. You'd face the mountain of the board's decision in Taku Kusar Jaru and the Attorney General.
But
You'd be shunted out.
It all comes back to Section 14.3, doesn't it?
Yeah.
Why
Yes.
is that there?
Yes.
It's not there to preclude jurisdiction on the basis that there wouldn't be jurisdiction under the State Liability and Proceedings Act.
Yes.
It's there to extend the scope
Indeed.
of the State Liability and Proceedings Act to cover a claim under section 14.
Yes. And may I answer my Lord Mance in this way? In judicial review proceedings, one cannot, for example, claim damages unless you had a pre-existing cause of action at common law. The Constitution expressly gives you a right to claim damages in the form of in the form of redress pursuant to section 14. That by itself separates it, in my view, because in judicial review, it's not a cause of action. The Constitution, however, gives you a cause of action. Judicial review doesn't give you a cause of action. There's no list between the parties. Some judgments go so far as to suggest that there are no parties, that the aggrieved citizen is moving in the name of the state or the crown.
I mean, doesn't it come down ultimately to the simple question, well, I don't mean the simple, but the short question under section 19.2, which is introduced by section 14.3, talking about different acts, but no matter. Well, the question being, yes or no, is this section 14 proceeding against the state? That's the only question. I didn't mean simple in terms of answer, but that's the actual question.
Indeed, no. Indeed.
I'm wondering whether we have to revisit Gary and Jurity, which were referred to by Mr. Guthrie, and which we can really look at very closely.
Yes.
Lord Bingham, in paragraph 21 of Gary, seems to be touching on that sort of problem.
17.
Tab 17, paragraph 21.
One always has to be careful, because it's sometimes a mistake to assume that all of the constitutions in the West Indies speak of one
I
God.
appreciate that. That's why I say we
Yes.
may have to look at it
in some way. It requires closer analysis. I mean, the Constitution of Grenada may very well be different. I'm not seeing immediately that this was a constitutional motion. I'm trying to, paragraph 4. He issued proceedings claiming a declaration that the law confiscating his property was void and of no effect. You see, my Lord, paragraph 4, if one looks in the judgment, the respondent was the Attorney
Paragraph
General.
4 of what?
Paragraph 4 of the judgment.
In Gary.
The Gary.
Okay.
At tab 17. What the appellant was doing in that case, my Lord, was that he sought a declaration that the People's Law of number 95 of 1979 contravened section 6 of the Constitution and was null and void. So it seems as though he was challenging an act of the constitutionality of an act of Parliament or some law that was made.
And then he got judgment for the money and
Yes, and then he got judgment because the law apparently was probably invalidated and the state wouldn't pay. And that was the issue that was before the board. It was an enforcement type proceeding in nature.
21 is dealing with the definition of civil proceedings in the Crown Proceedings Act, and it's not dealing with a situation where you've got a section 14.3.
Absolutely.
Yes. Can I just refer my lords to paragraph 23, which perhaps completes a discussion earlier with my Lord Mance, and it says in paragraph 23, this submission, it would seem, derived from the principle that mandamus only lies to compel a minister or public official to perform a duty, a statutory or public duty. But for reasons already given, the appellant is not constrained by principles governing applications for judicial review. Having proved the breach of a right protected by the Constitution, having obtained a money judgment and having failed to obtain full payment, he now seeks an effective, not merely a nominal remedy, and the court has the power to grant such a remedy. It's just a point of distinction, again, between judicial review and constitutional proceedings. My Lord, if I may, the jurity case and the issue of the deeming provision, one has to be careful about it because, you see, the case that eventually came before the board in Rees and Crane and these matters were judicial review proceedings. So that one can see that the deeming provision may have been necessary to secure an order for costs against the state. They were not constitutional motion proceedings alleging violation of a fundamental right as we are in this case. If there were such cases, it may very well be that there was no need for the deeming provision because the principle upon which we rest our argument here would have applied in any event. And that is to say, without the deeming provision, any of the constitutional or any service commission created by an act of parliament that cannot sue or be sued in its own right is part of the executive, and the Attorney General is the proper party for the purpose of a Section 14 action under the Constitution. The position may be different if it is a body that has an independent status and juridical character, and it's one that's capable of suing or being sued in its own name. And you will serve the Attorney General under the Supreme Court of Judicature Act if he wishes to be heard.
I'm sorry, I'm unclear. The service commissions, as defined, those 4 commissions, I mean, have they got independent juridical character and so forth?
No.
They haven't?
No.
I mean, are you saying they are absolutely in the identical position to the commission that we
Yes, that is what I'm saying, yes.
And what, and you couldn't get a cost order against them?
You can, yes. If in a judicial review proceeding, you will get a cost order against them. But the reason that amendment was came into being is because they were trying to levy on the individual members of the tribunal. And it was, this act was, an amendment was hastily rushed through Parliament, as it were, to deal with that. The point I'm making, however, is that in a constitutional motion against any involving action, discriminatory action by any of those service commissions, the proper party prior to and subsequent to that amendment would be the Attorney General and no one else. You would not have to name the commission as a defendant to that constitutional motion, either before or subsequent to that amendment. The position in constitutional law remains unaltered and unaffected by that amendment. It's one and the position remains the same. You would have to bring your constitutional motion against the Attorney General. One can well see, for example, my Lord, the sense in all of this. Suppose one sued a commission and the commission retained outside private counsel without reference to the Attorney General. There was a binding declaration that, they're entitled to damages and they violated the constitutional rights. And the monies have to come from the Attorney General's purse. I don't think that will sit well with the Attorney General, and I don't think the implications of of the practical considerations have been fully considered in this matter from a practical standpoint. But that is how in reality it is administered on the ground and how it operates. My Lord, there's one final minor but albeit important footnote for Carmel Smith, who is just a mere civil servant in all of this. And it's this, it's to point out that in the Court of Appeal, subsequent to the judgment being delivered, I had made an application to the court because they dealt only with costs in the Court of Appeal. And you'll see in the High Court, the judge had made no order as to costs. That order for no order as to costs in the High Court was made at a prior case management conference. And the judge expressed the view that if the state were to succeed before him, he will not give them their costs because they were late with filing their submissions. And they were late on 3 separate occasions and had flouted case management directions. I'd gone back to the Court of Appeal to point this out, that this was a sanction imposed and was one to bind the state, but not us. And in fact, the Court of Appeal, in a subsequent amended order, directed the appellant to pay the costs in both the Court of Appeal and the High Court in accordance with the approved cost budget in both courts. I've mentioned this to my learned friends, and we will in fact get the amended order if in the event there's any dispute or need for it. But we say that should the appeal be dismissed, we would be entitled to our costs in all three courts.
In all three courts?
Yes. But should the appellant succeed, the order for costs in the High Court should remain no order as to costs against them, because that was a sanction imposed by the trial judge that ought properly to remain as a result of continuous non-compliance with the rule, with the directions given at case management hearings.
What about costs here, given that it's a constitutional matter?
Lord, in the event the appeal is dismissed, we should have our costs. In the event the appeal should succeed, we'd ask that the board consider carefully that this is a matter of great general public and constitutional importance, and the position of the appellant as a mere civil servant who has in fact been dismissed or who's been suspended in effect is a rather tenuous one, and it's a matter where the trial may yet need to continue. And it may very well be that if the preliminary point succeeds, the cost order should be cost in the cause, as the case may be. But if we succeed on this preliminary point in limine, we should have our costs.
Can I just ask one final question? I'm afraid perhaps coming from behind on this, but on the question of the effect of Section 14, subsection 3, the State Liability Proceedings Act shall have effect. Does that necessarily, or actually, mean anything more than that if you're suing the state, you have to sue the Attorney General? It doesn't answer the question whether you're suing the state.
No. That might be one way to look at it, but it's still, we then fall back on whether or not this commission can be said to be part of the state.
Yes, so I mean, really Section 14, subsection 3 doesn't solve the problem at all. It just introduces the problem.
Well, that's
why is it there at all?
Well, it's there because otherwise, I mean, it's there for the same reason that Section 19 is there in relation to ordinary civil proceedings. This extends Section 19 to constitutional proceedings, because otherwise the State Liability Proceedings Act is pretty clearly dealing with ordinary civil proceedings. It expressly excludes Crown side proceedings.
Except to say the query, why would the draftsman of the Constitution want to make express reference and incorporate the State Liability Proceedings Act if it was meant to govern civil proceedings and constitutional motions were not intended to be part of civil proceedings?
Oh, well, that I can see. I mean, that seems to me the obvious point.
Yes.
And the question is whether there's a further point in Section 43. But the obvious point is to say, if you're bringing a constitutional motion against the state, then you bring it against the Attorney General. But it doesn't actually tell you when you're bringing it against the state as opposed to not.
I'll leave it in the hands of my lawyers by reminding this board of one salutary principle, and it is this. This Constitution and the fundamental rights provision and the enforcement provision in Section 14 is meant to regulate the conduct and let citizens on the ground, not lawyers who are trained in English or West Indian universities, do all these intellectual gymnastics to figure out who to sue when their human rights are violated. And I'll ask that the principle of that there be certainty in the laws, and in particular the fundamental rights provisions that are meant to govern the ordinary citizens and the man in the Clapham omnibus and our equivalent, which is called the maxi taxi, that be borne in mind. We ought not to complicate these matters. Unnecessary complications really undermine the very essence of the fundamental rights provision, which are entrenched and deemed to be sacred in our Constitution. Thank you, members.
We'll adjourn until 2 o'clock.